Hi, everyone. Good afternoon. We are just going to give it a few more moments here to let folks gather in and join, and we'll get started in just a few moments. Right, I think we're going to go ahead and get started. Welcome, everyone, to the Bay Area Council webinar series, where we discuss the biggest public policy challenges facing the Bay Area and California. I'm Adrian Covert, Senior Vice President of Public Policy at the Bay Area Council. One of the region's toughest issues, no surprise, is homelessness. Homelessness routinely tops regional polls as the top concern of Bay Area residents and has in recent years garnered national and international attention, unflattering attention, including from the United Nations and others. For today's discussion, I'm really excited. We're going to be diving into something that I get asked about all the time, which is why do homeless encampments persist despite obviously violating state law and local ordinances? The answer to that question is complex, and it often involves the conflict between laws governing access to public space and the civil rights of homeless residents. And this tension was at the heart of a recent landmark case in the Ninth Circuit, Martin versus Boise, which has reshaped the legal framework surrounding encampment resolutions, and which we'll be discussing today with our three guests, Brendan Adams and Trevor Taniguchi, associates with law firm Hanson Bridgett, and Cynthia Nagendra, the Deputy Director of the San Francisco Department of Homelessness and Supportive Housing. And before we begin, I wanted to just start out by sharing the region's latest homelessness figures. You might have seen in the news over the past few weeks that the Bay Area counties have begun releasing their draft point-in-time counts. And for folks who are unfamiliar, the point-in-time count is a national effort that's held every 2 years to physically count, manually count, every homeless person living in the United States. The counts are conducted early in the morning in a winter time to maximize the number of homeless people that are sleeping in shelters to increase the count's accuracy. And the 2022 point-in-time counts are the very first conducted since the beginning of the COVID-19 pandemic, which makes them notable and highly anticipated, and the results are mixed. Homelessness is up about 9% across the region for all 7 of the 9 counties that are reporting, including significant jumps in unsheltered homelessness in Contra Costa County, nearly a 50% jump there, as well as 20% jumps in Alameda County, overweighing, I think, the modest good news of a slight dip in homelessness in San Francisco and in Santa Clara counties on the unsheltered homelessness front. So against this context of growing homelessness in the Bay Area, though perhaps not as quickly growing as some had feared at the start of the COVID-19 pandemic, we still have a growing population and some tension in our legal framework on how to do it. So with that, I would like to turn it over first to Brendan Adams and Trevor Taniguchi to discuss a Just the Facts presentation about the law surrounding homelessness and homeless encampments and the tension between their civil rights. And then we'll get some context from Cynthia. And then I want to turn it over to folks who are dialing in to answer questions, to ask questions. If you have them, please think of them and throw them in the question box, and we'll get to you towards the end of the program. So with that, Brendan and Trevor, would you like to take it away?
Yes, gladly. Thank you, Adrian. Once again, my name is Brendan Adams, and I'm an associate with the law firm Hanson Bridgett here in our San Francisco office. I'm going to start today talking about Martin v. Boise, which is, as Adrian mentioned, the case that has garnered a lot of attention in terms of cities and other jurisdictions' interactions with encampments and their ability to sweep encampments. Normally when we talk about a case, we start with the facts and then we tell you what the court held. But in this case, I'm going to go a little bit in reverse and start with the holding of the case. And the reason for that is, there are two reasons for that. First is that I want to emphasize that this is a criminal issue. Martin v. Boise deals with the 8th Amendment. For our purposes, it's a narrow holding related to the 8th Amendment regarding what the state can punish for with criminal sanctions. And the second reason I want to start with the holding is because it's actually not a new holding in a way. The Martin case is not the first time a court has come to this conclusion. In fact, as far back as 2005, courts have come to a similar conclusion. And that conclusion is that cities cannot criminalize camping outside when there's no alternative. That's basically the one sentence summary of what the court held here. But courts have held that as far back as 2005 in a decision out of the city of LA. A court came to that same conclusion. It was later vacated as a result of a settlement between the city of LA and the plaintiffs in that case, which is why the Martin case on its face is new. So I'll move along to what actually happened in Boise. The city of Boise had 2 ordinances. The first was the called the Disorderly Conduct Ordinance, and it prohibited occupying, lodging, or sleeping in any building, structure, or place, whether public or private, without permission. The second ordinance, the Camping Ordinance, prohibited any use of the streets, sidewalks, parks, or public places as a camping place at any time. And it defined the camp or camping as any use of public property as a place of dwelling or residence, or as a living accommodation anytime between sunset and sunrise. So we're talking about 2 rather broad ordinances here that criminalize the act of camping outside or sleeping in a public place. Now, importantly, the reason I started with the holding in this case is because Boise actually was aware of this requirement, that this legal concept that such ordinances could not be enforced without shelter beds being available. As far back as 2015, Boise had amended their ordinance to say that it would not be enforced unless shelter beds were available. In the first 3 months of 2015, after that amendment, Boise issued 175 citations of these 2 ordinances in the first 3 months of 2015. The 6 plaintiffs in Martin v. Boise were all criminally convicted under one of these 2 ordinances, including Pamela Hawks and the named plaintiff, Robert Martin. Pamela Hawks served time in jail for her violation. As of 2018, in Ada County, where Boise is located, there were 867 homeless people, according to that point in time count that Adrian just described. The year before that, there were 2 religious organizations that were running 3 shelters, a total of 3 shelters in Ada County. Combined, those shelters offered 354 beds and 92 mats. Again, 867 homeless people in 2018, and as of 2017, 354 beds, 92 mats. There was 1 shelter sanctuary that was open to men and women, and it gave people priority if they had been there the night before. Anyone who had not stayed in the shelter the night before had to sign up for a waiting list, and they could be admitted off the waiting list starting at 9 p.m. The other 2 shelters were run by the Boise Rescue Mission. The Boise Rescue Mission shelter separated men and women, and outside of the wintertime, the Rescue Mission limited men to 17 consecutive nights in the shelter and women and children to 30 consecutive nights in the shelter. All residents were required to check in on every single one of those nights, and any resident who did not check in to on one of those nights was prohibited from returning for the next 30 days. You could check into one of those 2 rescue mission facilities between 4 and 5:30. You had to check in from that time, and then the rescue mission had until 8 p.m. to let you know that you would be admitted. Generally, if you arrived after 8 p.m., you would be turned away. So like I mentioned, the city of Boise was on paper only enforcing these ordinances when there was not shelter bed available. However, the court, after going through these facts that I just listed, the court highlighted that the shelters were required to self-report when they were at capacity. One of the shelters reported that it was at capacity on 38% of nights in 2014. However, the rescue mission stated in court that it had a policy of never turning away people for lack of capacity, and said that they would never tell the city that there were no shelter beds available. Again, remember that the rescue mission did have an official policy of turning people away starting at 8 p.m. So the plaintiffs that I mentioned earlier, Pamela Hawks, Robert Martin, and others, were convicted under these ordinances and sued. And their claim, once again, was an Eighth Amendment claim, saying that the city of Boise, asking that the city of Boise could not enforce criminal ordinances on homeless individuals who could not obtain shelter. And again, the court held under the Eighth Amendment that the city was prohibited from doing so. So how does the court come to this conclusion? So they go to the Eighth Amendment of the Constitution, which places limits on what activity the government can criminalize. The leading Eighth Amendment case in this field is Robinson v. California. In Robinson, back in 1962, the court said, even 1 day in prison would be a cruel and unusual punishment for the quote unquote crime of having a common cold. So Robinson is generally understood to prohibit the criminalization of a status as opposed to acts. So the court cannot punish you for being poor. The court can only, a city can only punish you for an act, a volitional act. So the court reasoned in Boise that criminalizing sitting, sleeping, or laying for homeless people who had nowhere else to go amounted to criminalizing the status of being homeless. There's discussion in the case about distinguishing this from a line of cases permitting criminal punishment of public drunkenness. But the court's reasoning in this sense sort of makes sense. If an individual doesn't have a place to sleep, there's no way to avoid sleeping. It's something you must do. So if you are too poor to have a place to live, a city cannot punish you for sleeping in the only place available to you. The court went on to find in Boise, in Martin, that the fact that the rescue mission never turned residents away for lack of capacity did not mean that shelter beds were always available in Boise. The check-in policies of the shelters were not coordinated, meaning you could be rejected from the one shelter's waiting list for capacity reasons at 9 p.m. after the rescue mission had already closed its doors for the night. Furthermore, the rescue mission's attendance policies could prevent an individual from using those shelters for months at a time. So with these facts in mind, the court found that the city of Boise, by issuing all of these citations, was criminally punishing people for the involuntary act of being poor and having nowhere else to go, and struck down the plaintiff's convictions in this case. So that is, again, how the courts will look at the act of criminalizing sleeping on the streets, living on the streets. And that's just one facet of the legal analysis around managing or sweeping an encampment. So for some of the other considerations, I'm going to hand it over to Trevor.
Thanks, Brendan. We thought it would be helpful to cover a recent court decision from the Ninth Circuit Court of Appeals. The case is entitled, Where Do We Go, Berkeley versus California Department of Transportation, Caltrans. The decision was ruled April 27th, 2022, so rather recent, just several weeks ago. And the case involved or stemmed around the issue of Caltrans' decision to clear encampments along an exit ramp for I-80 between the borders of the cities of Emeryville and Berkeley. And the group Where Do We Go Berkeley, on behalf of several disabled homeless residents of the encampment, first filed a restraining order and then were granted an injunction by a federal district court, which prevented or ordered Caltrans to wait at least 6 months before clearing the encampment. And the Ninth Circuit overturned this. And it was an interesting case in the sense of Martin v. Boise dealt with the criminalization of a status. So the status, as Brendan mentioned, of not having a home, not having economic resources to be able to provide for yourself, to have shelter or permanent shelter. This Berkeley case, or Where We Go Berkeley versus Caltrans, specifically dealt with the plaintiffs argued that Caltrans was violating the Americans with Disabilities Act by not providing the people that they were removing from the encampment with an accessible shelter. And so this is a different type of argument, and a rather unique one in our view, of how different groups, especially homeless advocate groups, are approaching actions by different public entities to clear specific spaces. The Ninth Circuit overturned the district court's appeal, specifically on the grounds of that Caltrans was not violating the ADA. There were other claims that were brought by the plaintiffs that were not ruled on, but I think are important to just be mindful of. Whenever you're removing or going through an encampment, there's always due process considerations to take into account, as well as Fourth Amendment claims of unlawful searches and seizures of property, because in most cases these encampments have lots and lots of things that are that the residents of these encampments have along with them. So the court held that the 6-month delay was not a reasonable modification of Caltrans' encampment clearing program, and that the harm of the delay to Caltrans was not properly weighted in the district court's analysis. And I think it's important to just kind of caution that a lot of the newspaper headings around this case where Caltrans' authority to clear encampments has been verified by the courts. And the court decision doesn't quite go that far. Because the case that started this controversy was an injunction, which is the court saying, Caltrans, you cannot do this unless you meet these certain criteria. It's not just a blanket approval of Caltrans' encampment program. So that's the key fact to where there still is this analysis that needs to be done. But the key takeaways from this case, I think, can be replicated or followed by other types of public entities. And the first one is that the Ninth Circuit gave an incredible amount of deference to the fact that Caltrans had an encampment clearing program or a policy. So Caltrans' policy had 3 criteria or 3 levels of how they would deem a certain encampment on their property. One being where it was the imminent threat to public safety or health. And so they would typically give 72 hours notice and try and work with local organizations, local advocacy groups to help gather and inform those residing in the encampment and trying to find then a shelter or some other type of semi-permanent housing or temporary housing. The second criteria was one in which Caltrans would give a little bit more leeway. Typically, from our understanding, it was they would work with, again, groups to try and find them supportive housing, but would give a longer lead time, not necessarily 72 hours. And the last category that Caltrans would use would simply be that they would, to the lowest level, they would just monitor the encampment and send crews out to clean up any trash piling up or anything that might be deemed a public health or safety risk or hazardous waste and things of that nature. So the court really hones in on the fact that Caltrans had a policy, they followed the policy, and then they give a great amount of deference to the fact that Caltrans in this particular case had deemed this encampment to be the level 1 type of encampment where it was a serious threat to the public health and safety. And so that's an important aspect, a key takeaway, I think, for any group or any organization or any public entity approaching this type of situation is, the Ninth Circuit, although it's not specifically called out, has given it's somewhat tacit approval to the use of a policy and that it's enforced. And the level of deference seems to be pretty great, at least in this one holding. The second takeaway is sort of a new facet to this idea, or this one of the complexities that go with clearing an encampment, which is the ADA. It's something that we run across in many different aspects of day-to-day life, of running the business, of public entity, providing accessible facilities. This is one of the first times I've seen this argument come up in the context of clearing an encampment. And the court didn't completely dismiss the plaintiff's position that the ADA needs to be considered. It actually dismissed Caltrans' argument that the ADA didn't apply because this part of their property was not open to the public. The court still went through an analysis to determine whether the modification imposed by the district court was reasonable in light of the ADA. So just another layer of complexity that public entities are going to have to be mindful of when going through and addressing encampments. There's this additional layer of the ADA that now I think has come to the forefront in just with this case. So turning from that and that recent case, some recent trends we were seeing across the state, just as far as when we talk with our counterparts who are city attorneys and other councils representing public entities. After the Boise decision, there was almost an immediate sort of pause on enforcement of camping ordinances, curfew ordinances, as cities and different public entities tried to figure out like what the legal landscape was, what could you do essentially as far as enforcing your ordinances. And since then, I think we've seen a growing trend in the use of teams in the sense of a multidisciplinary team of not just having a police officer or a sheriff or a law enforcement individual going out and citing, but having an actual collective team made up of essentially a social worker, a mental health specialist, and maybe just a general individual that's assigned with making contact with homeless people and trying to build rapport and relationships to try and navigate them towards supportive housing or other benefits in which that might help them leave the particular area they're with and potentially, in the ideal world, end their homelessness situation. So that is one growing trend we're seeing rather recently. Another trend we're seeing too is that some cities are entering into settlement agreements, with local groups or plaintiffs who are homeless that are being represented. And as part of those settlement agreements, there's a commitment to building shelters, which is a key component of the Martin v. Boise case. So, it's not across the state, but we are seeing a growing number of settlement agreements in which local jurisdictions are agreeing or committing to providing for either building a shelter or partnering with an agency to provide shelters for homeless individuals. And one parting thought, I think, is there are a variety of different approaches to addressing this issue. And there are still some cities that are in public jurisdictions that are enforcing their curfews, issuing citations for camping. So there's a real mix across the state and diverse reasons as to why, public policy reasons and other reasons as to why a city or a county or a different public entity chooses to do what it does. So there are so many different factors that go into it. So we just want to highlight that there are many different approaches being employed by jurisdictions across the state.
Yeah, if I could jump back in, I forgot to mention one thing, and I think Trevor sort of led me to this, that reading this Martin v. Boise decision, I think one of the takeaways is that you can say on paper, just as Boise did, that the ordinance will not be enforced. But if there are practical realities on the ground that are preventing that shelter from actually being available, the courts are not going to look on that favorably. And so these settlement agreements and other collaborative approaches Trevor was just talking about, I think are important in terms of actually figuring out what is needed to get people shelter, so that a court won't look at your program and say, you haven't really actually provided anybody with shelter. You haven't actually checked to see whether there's shelter or not. So I think that's one final takeaway from that Martin case.
Great, thank you both. I've got a lot of questions on these, on both of some of the things that you mentioned. But first, I want to get Cynthia an opportunity to weigh in. Cynthia, you represent the city and county, California's only combined city and county in this space. And so I'm wondering if you can reflect on on how Martin impacted, and subsequent case law impacted, the city's approach to encampment resolutions.
Sure, thank you so much. So I wanted to start by just giving a little bit of context into sort of how we approach homelessness and the solutions, to sort of give some context to our encampment resolution and how we sort of are working within Boise, and the guardrails that are set up there, and kind of how there are some things that we have to kind of grapple with to make that work. So, we come at the very complex issue of homelessness from a couple different places. One, that the drivers of homelessness we know are structural and economic, that it's skyrocketing housing costs, very inadequate wages that aren't keeping up with those housing costs, and then just widespread systemic failures that have really allowed people to fall through the cracks to get into a situation where they are in this deep housing crisis. And it's happening to more and more folks in the Bay Area because of housing costs. And I often cite a Zillow study that was published in 2019 that shows that just increases in rent in California, such as like a 5% increase in rent in LA, results in about 2,000 more people experiencing homelessness. So coming from that context of the drivers, the solutions we also know are about permanent housing and the services that people need to stabilize in that housing. And for the most part, and we see a lot of people outside struggling with a lot of different complex issues, but a large percentage of the homeless population in the Bay Area needs rent money, needs money to pay for housing and to pay for food, and to be able to make it. So when we look at our, kind of our evidence-based solutions that we've had in the homelessness field for many years now, and understanding that in the Bay Area, housing, which is a market-based solution, obviously, and the shortage of housing, trying to kind of grapple with making sure we're providing permanent solutions to people's homelessness. We have invested heavily in San Francisco, luckily, because we have been fortunate to have a lot of local resources in shelter and permanent housing and services. And we've been able to also invest more in our outreach and encampment resolution teams, what we call our Healthy Streets Operations Center, and several street response teams. And I'll talk about that in a second. But I wanted to say those investments in shelter and permanent housing, we're starting to see, they're still not to scale, but the permanent housing resources are starting to sort of evidence, as we saw in our our recent point in time count, where we did see a slight reduction overall in homelessness, about 3.5%, and a 15% reduction in our unsheltered street homelessness, so people living outside. And we can see that really correlates with the large investments we've made in housing resources and shelter as well. And also, importantly, the type of shelter. We were able during the pandemic to open up a lot of hotel rooms during as shelter-in-place hotels during COVID, and what we're calling non-congregate shelter. In other words, they're temporary, but it's a room. You can bring your things. You have, resources. You have a bathroom, all of those things, and that's a much more appealing resource for people. So a lot of people came in, over 2,000 people, and now we've made a commitment to house all those folks. So we've housed over, I think, almost 1,100 people. So I bring all of that up in the context of encampment resolution because, and sort of Boise, because without the permanent resources, or the shelter and the permanent housing resources, giving people the opportunity to actually resolve their housing crisis, it's moving people around, or asking them to be, or criminalizing them in any way because they're experiencing homelessness and have no other no resolution, as Boise is outlining the parameters for, is not an effective solution, right? So we want to make sure that even in our solutions, we are really approaching people with that idea, that mind to that sort of structural permanent response. So Boise provides guideposts for how communities can resolve encampments, and it prohibits jurisdictions such as ours from removing people, as you've heard, experiencing homelessness without a shelter option, and hopefully more permanent option and a pathway to housing. And we've always known that and that's really shaped our encampment strategy, but we started our encampment strategy, our resolution strategy before Boise was decided, that it kind of codified a lot of what we were already doing. And we've been also working to know that, we know that offering that minimum is not enough, right? Just offering shelter or just offering kind of a resource that you need to have all of the other pieces in place as well. So these legal decisions are really have provided some guideposts, and they're practical and ethically necessary in some cases, but we know that we have to sort of be thinking about all of these other pieces in terms of how to actually resolve people's homelessness. And so our encampment resolution strategy, and we sort of in 2018 formed something called the Healthy Streets Operations Center. And that is to coordinate the city's response amongst several departments. So it's a collaborative effort of the Department of Emergency Management and the Department of Homelessness and Supportive Housing, our outreach teams, the Department of Public Health, law enforcement. And so we do these sort of a collaborative approach to encampment resolution, and we prioritize which sort of health and safety needs we need to attend to. But we have to offer available shelter and services to people living on the street and in these encampments before we actually have them removed or cleared for health and safety reasons. And so that ongoing need for shelter and housing and the availability of it, as well as actually making it designed to respond to people's needs, because sometimes shelter is not an appealing option. Brendan described the shelter in that case. A lot of shelter is asking people to do a lot of things that are not conducive to their needs. And so it's an ongoing need to make sure we're investing in permanent housing and pathways to housing. Shelter is a really important part of that. But we have to, if you only invest in shelter, you're going to have to keep building shelter, right? People need a way to exit shelter. And so that we're really thinking about prevention, shelter, and housing together, because a lot of people are going to keep falling into homelessness because of the housing costs. And we want to prevent them from falling in. And we also want to get them into a permanent situation as quickly as possible. So that is kind of wrapped around and informing our encampment resolution strategy, and why we're making so many investments in making sure people we're not just managing the problem, but solving it.
Great, thanks so much, Cynthia. I think I've got a couple questions that I'll start off with, and I'll go straight to you since you had just finished your talk. But let's go into the latest PIT counts, point-in-time counts for San Francisco. San Francisco faced a 15% decline in its overall homelessness rate. I believe it's the first decline in San Francisco's homeless rate in at least a decade. It's been steadily going upwards. A drop in the unsheltered rate. How much of that is to do with Project Home Key and Project Room Key, Governor Newsom's signature initiatives, versus a Proposition C expanding the local inventory of shelter options?
Both have been extraordinarily helpful. I mean, the Proposition C, a local tax, a gross tax receipt that was voted on by the voters in 2018, but didn't actually, we didn't actually get the funds or the approval to use the funds until 2021. And at that same time, we were getting these federal resources and the state resources to do Project Room Key, which was to open up all those hotel rooms for shelter in place. And we took a very serious advantage of those resources, as well as the federal FEMA resources that will subsidize when we get reimbursed some of those hotel rooms, but not all. So the services, the meals, all of those things, we had to find local funds for. Proposition C gave us the chance to unlock those state and federal funds, right? So it was able to, the braiding of those funds has allowed us to both give us the services we need to get people into shelter, and again, getting people into the services structure that they need to actually get out and to get to housing. And we're able to use our Prop C dollars to then permanently house all those folks, right? So without both of those pieces, we would have definitely we have our general funds, but it really helped us expand our system in ways and learn about, that in situations where we have an emergency and we bring a lot of resources to bear and we focus very targetedly on permanently housing people, we will see a difference. And we will see more, I think, in the next 2 years. We're obviously really excited to see that there's been a decrease and that some of these investments are working. And I think we'll see now in the next 2 years exactly how that's going to build.
Great, that makes a lot of sense. And I think it would make a lot of sense to folks listening how the state and the local pieces fit together. It's a tremendous influx of new resources that I don't think anyone's ever really seen before. My next question is over to the Hanson Bridgett team, Trevor and Brendan. You mentioned in the Caltrans example over in Berkeley, that was a level 1 type of encampment, meaning, and correct me if I'm wrong, highest risk, highest urgency to the public and to the folks experiencing homelessness at that encampment, for that encampment to be resolved. Are you aware of any case studies talking that look at homeless encampments in watersheds? You see in a lot of places in the Bay Area and elsewhere in California, homeless encampments spring up in areas that serve essentially as drinking water infrastructure for rivers and streams that flow into some catchment basin or some other part of the drinking water infrastructure. And I'm wondering, is that considered a level 1 type of encampment, or has it not been really looked at yet?
Yeah, I'm not aware of a study specific to watershed, and I actually don't have the background as to what drove the development of the Caltrans interim policy regarding clearing encampments. But I think my main takeaway of my reading of the case is that Caltrans did have a policy. So it's not just saying we're going to go out every 72 hours and clear our spaces. So there's this defined policy. And I think there's potential for that to be replicated in the context of a watershed or a water district that has critical infrastructure that has a high chance of being contaminated or damaged by encampments. And so I think it's a potential avenue for different jurisdictions to consider to the extent that they want to conduct their own study. I think it's helpful to bolster any type of policy or procedure that's implemented. But I think the levels, from my reading of the case were helpful because it showed that there was an evaluation on the part of Caltrans. It's not just saying you have 72 hours. It's saying, okay, here's level 1, here's level 2, and here's level 3. Level 3 being low risk. We're just going to make sure you're not, maintaining things here in an unsafe manner, hazardous waste that could, endanger somebody. So I think that's a key takeaway from the Ninth Circuit case. And, it remains to be seen as far as the validity of that in the context of a water district or a water agency.
Would you say then, though, that the Caltrans policy then could be a framework that could be used by other special districts like the Bay Area's major water agencies?
I think there's a chance, and a lot. It's sort of a layered, nuanced answer, and not to give a lawyerly answer, but there's so many different components that go into the court's decision, and so starting out, Caltrans under the Streets and Highway Code has broad discretion over authority over their public property. And so if you can draw parallels to the authority granted in law with another public entity that they might have, a water agency or water district might have that similar type of authority over their property or infrastructure or areas. I do think it is a potential blueprint to follow as far as implementing a potential encampment clearing policy, strategy, or program. And obviously that's going to take some digging into, with their counsel and figuring out, are there parallels that we could draw upon in authority and mirroring the development of how the Caltrans policy came to fruition.
Great. I think that would be really helpful then to share with members of the council and with the public the Caltrans policy. I know particularly I've heard from a lot of water agencies who are struggling with how to ethically protect public health and safety while respecting the civil rights of people experiencing homelessness in the lands that they are the stewards of. So my next question is over to Cynthia. I'd like for, a few years ago, I was speaking with someone at the Department of Supportive Housing and Homelessness, and they had mentioned that San Francisco, something along the lines of San Francisco could build any number of shelters and permanent housing units. And it wouldn't solve the homelessness problem in San Francisco so long as there remain to be tens of thousands of homeless residents in the surrounding counties. So I want to get your take on the regional effect of homelessness in San Francisco, particularly with regards to something that I found interesting, looking at the point in time counts from 2022, the housing inventory counts that count the number of shelter beds and permanent supportive housing units that are offered. On a population basis, per capita basis, San Francisco provides more permanent supportive housing than any other continuum of care in the United States, except for maybe Washington, DC. It's right up there. And over the last 10 years, San Francisco has actually grown its shelter inventory by about 30%, whereas the rest of the region has actually shrunk their shelter inventory. So it seems like the right hand doesn't really know what the left hand is doing if you look at the region as an entire region. And so, how do you make progress without aligning the other counties in the Bay Area?
I mean, this has been an ongoing conversation, as you're mentioning, for many years in the area, especially as the cost of housing becomes more and more expensive everywhere. So insofar as people will often ask, like, well, why don't people move to other areas where it's more affordable? Well, that is actually becoming almost impossible. And also for the primary reasons of people not wanting to leave their communities, their jobs, their schools, even if they did move out like into another county, it's becoming harder and harder to do that, right? So the region, I think, is also probably seeing, I wonder if it's even seeing less kind of fluidity, but our data systems are not connected regionally, where we are actually we're having regional conversations about seeing how people are moving throughout our county systems, because sometimes we're paying people's rent or providing them a voucher or something, and it's much cheaper to live maybe, 3 counties away. And people will even commute very far for their jobs because they have to, not because they want to, but because they have to. And I mention that because we're not as able to kind of get that visibility of how people are moving through, throughout the region. But I do want to say is recognizing that this regional issue has been a problem. And like you said, the sort of coordination of making sure that we're thinking about the solution in a much more aligned and coordinated way in our investments in the solutions. There's an organization called All Home California that's based in Alameda County that has started about 1.5 ago, 2 years ago, recognizing this problem, brought 9 counties together and created a steering committee and a number of groups. Many mayors, our mayor signed on, the Oakland mayor signed on, to a regional action plan. So there's a regional action plan on homelessness that is really trying to look at things in a regional way, in the way that you're talking about. But it's the first time we've ever done that in such a coordinated way. And so things like, what our investments are as a region, what our solutions are, what our everyone has different city and county dynamics. Here in San Francisco, we're lucky to have one city and county, which makes things a little bit easier to make decisions versus a lot of the other counties in the surrounding area. So the things that we know we need are coordinated data systems. We know that people are moving in and out. We're trying not to displace a lot of people. So we are trying to understand where it is that people are going, and are they becoming homeless there, or they move to another place? We don't know that answer very well, and we need to be able to really know how to respond. We still know prevention, shelter, housing; those things have to come together to scale, and we right size each of those interventions. But we, in all of our counties, so having a ton of shelter in one county is going to be, and only having housing in another is not going to be enough. But that regional approach is, as you're saying, really important. We're starting to move more and more towards that, but connecting all of those pieces is definitely very complicated.
Indeed it is. And I want to let you know that the Bay Area Councils actually did endorse the regional action plan by All Home. And in fact, Tamika Moss co-chairs the Bay Area Council's Homelessness Committee. And so we're absolutely committed to the regional solutions to this. I want to ask another question to Trevor and Brendan. And actually, Cynthia, I'd like to get your thoughts on this. So Sacramento, the city of Sacramento, is considering a ballot measure would go to the voters that would allow the city to enforce no camping ordinances on homeless shelters if the city can provide and expand its shelter inventory to meet about 60% of the homeless population. And I hadn't heard of an approach like that before. 60%, while it would represent a massive enlargement of the city of Sacramento's shelter inventory, it's 60% a threshold that would meet the goals and objectives and the standards set by Martin.
Yeah, I can comment on that. I think it's tempting the way Martin has been discussed to search for some golden number. We always want a goal to work towards, and that provides a nice, clean, easy solution. And once we get to that point, like, we can do whatever we want. But I think that really is a misreading of the case. I think, if anything, the case makes it clear that it's more about, you've got to think about whether people have an option. Do people have somewhere to go? And if building that number of shelter beds means that there is always a place for someone to go, then that ordinance, that may hold up to judicial scrutiny. But if you build all these shelter beds and they all close at 5 p.m. and you're banned from all of them if you miss one day, then I really don't think it's going to be the sort of silver bullet that people are looking for. So I know it's hard and it's not a satisfying answer, but again, I go back to the law and I go back to the 8th Amendment, and I would encourage, I guess we're probably speaking to business leaders, but I would encourage my clients to think about the 8th Amendment in terms of the criminalization and think, are we giving people an option to live their life? And if you're not, then it's not going to pass judicial scrutiny.
Interesting. Yeah. So it's not just about the inventory amount, it's about the ability of those beds and the service provided at those shelters to meet people's needs. Cynthia, you were going to weigh in?
Yeah, I couldn't agree more with what certainly I can't weigh in on the legality exactly in the way that Brendan can, but I do agree that if you look at the problem from a lens of what is actually going to solve the issue in a way that is, that community members across the board want to see less. We don't want to see people in our communities in these, in these situations. Well, then putting people into shelter that isn't going to be providing them the services and supports that they need to get into a permanent housing situation, or at least resolve their issues in whatever ways that they need help, then yes, you could just be building shelter forever also, because you'll need more and more shelter, and people will just come back out on the streets. You won't be actually reducing homelessness. You'll be expanding shelter and then kind of not having that throughput. And you've seen this in other communities. The number of people will probably still increase in terms of homelessness.
Yeah, I just wanted to refine my point a bit and say that the holding of Martin is that the shelter must be available, not it must exist. It must be available. I think to sum it all up is in a legal sense how I would focus that.
Great. And Trevor, did you want to weigh in on that at all, or did Brendan cover the main points on that one?
No, Brendan did a great job. I'm from Sacramento. I live in Sacramento, but I think it just highlights this constant tension and the complexity in dealing with homelessness as you have trying to strike a balance between non-homeless people who have neighborhoods and want to, go through the community and see certain things versus addressing the homeless situation. So there is constantly a tension of pulling interests in every which way, which just makes this such a dynamic issue to try and tackle. And I think, yeah, it's an interesting approach for sure. And to see where it ends up will be very interesting.
I wanted to just say that, it sort of sets us up into this false choice that it has to be either you're sleeping on the street or you're going into shelter, but really there's a both and, which is that we can provide shelter and housing and have a way for people. We don't want people to be on the street, but we need to provide available dignified, actual, solutions to those resources, to folks who are in those situations, so that people can actually have a permanent resolution. And I think that's what we're all really looking for.
Great. This has been a fantastic discussion. We've covered a lot of issues. Typically right now, we would turn it over to audience questions. But as I understand, there was a glitch in our invite system after 2 years of doing Bay Area Council webinars. And unfortunately, no one has been able to join. But that is okay, because we get most of our viewers on the recorded end when we share it as part of our weekly newsletter. So unfortunately, we're not going to have questions from an audience, which is unfortunate to say the least. However, the information that's been provided here has been no doubt really valuable, and it gets to a lot of the questions that I receive all the time. And not being a lawyer, I'm of a very limited utility to answer them. So with that, let me ask folks for closing points very briefly, and then I'll do a sign off, and apologies to the folks who wanted to be here today but couldn't, and I'll encourage them to send in some email questions if they have any, and maybe I could ask you all to keep in mind your inboxes. I might send you an aggregated list of a couple questions that folks might have. So with that, any closing statements or thoughts based on our conversation here today? I'll start with you, Brendan.
Sure. I think I would reiterate what I mentioned before, which is to be very mindful of what Boise actually stands for, and that's for the fact that shelter must be available. Not that it must exist, but it must be available to these people, and to people, and you cities are not going to be able to punish people who have no other option. And so, it's going to be tough to make. These are going to be fact-based situations. It needs to be dealt with on an encampment level, on a city level, on a water district level, on an individual level. And I think that's what courts are going to expect.
And thank you, Brendan. Trevor?
Yeah, and I think just building off what Brendan said, and one of my key takeaways is that Boise v. Martin isn't doom and gloom, the end for tools available to the city. I think if anything, it's forced public agencies and entities to be more collaborative, to develop more innovative solutions and approaches to dealing with homelessness. And so if we can continue down this path of trying to be creative, responsive to the situations that are occurring in our respective communities, I think there's a path forward with Martin being the guidepost, as Cynthia mentioned. So, I think it's promising, as Caltrans has one example. It's not the only example. And I'm sure as we continue to work down this path that we're going to see more innovative approaches, more creative solutions that hopefully somewhat mitigate the homelessness issue.
Thanks, Trevor. And how about you, Cynthia?
Yeah, I couldn't agree more with both with Brendan and Trevor's concluding statements, and just that, criminalization in communities across the country has not worked to reduce homelessness without real solutions on the other end, as I've said many times. But so just criminalizing it alone, I think, doesn't work. And Martin, sort of helps us, as Trevor just said, kind of be much more intentional and collaborative about actually designing programs and solutions that are going to be responsive to people's needs, rather than kind of just moving people around and putting a Band-Aid on the problem. So I think that it actually really does encourage us to be much more intentional with our investments.
Fantastic. Well, I want to thank you, Cynthia. Thank you, Brendan, and thank you, Trevor. Thank you, the Hanson Bridgett team, for putting together a lot of research and background into the case law surrounding Martin v. Boise and its aftermath. I want to apologize to the folks who wanted to participate in this webinar, but due to a technical glitch, we could not have you on today. However, I do encourage folks who are watching this to send me an email with questions that you have for our panelists, and I'll be sure to forward them and do a follow-up note to everyone who RSVP'd to this, as well as to our homelessness committee, with answered questions from you all on how on the topics that we discussed here today. So with that, again, thank you and have a good rest of your afternoon.
Thank you so much.